Closing arguments in the bail application for Nandipha Magudumana are currently underway at the Bloemfontein Magistrate's Court. Magudumana's legal team has highlighted what it believes are a number of discrepancies with the state's handling of the case. Among some of the issues raised were the state confiscating her travel documents and its accusation that the address she gave to the investigating officer was misleading. The matter was rolled over to today after an emotional Magudumana told the court through her lawyers last week that she was forced to leave the country following threats made by convicted rapist and murderer Thabo Bester. In her affidavit, Magudumana says that she was scared, defenseless and helpless with no one to report the threats to.
To produce evidence and not merely speculate, produce tangible evidence to the effect that there is a likelihood that the applicant will attempt to evade her trial. In this instance, Your Worship, the applicant made it quite clear, played open cards to this honorable court, that I have travel documents, but it has been seized. But it does not even end there. My learned colleague eloquently put forward a point that is crucial for the determination of this aspect. To say the state in its own opposing affidavit indicated how the applicant has been traveling in and outside the Republic of South Africa. But in this instance, the accused's passport the applicant's passport is confiscated.
Okay, after spending the better part of the day hearing arguments or closing arguments from the defense and the state, we take a look at the legalities of it all. Khumisi Kganare is a legal analyst. Thank you very much, Khumisi, for your time this afternoon. Perhaps let's start with the defense, arguing that there is a charge that does not necessarily speak to Schedule 5, but rather falls under the ambit of Schedule 1. Were you convinced that indeed, or did they manage, according to your perception, to convince the court that indeed that is not a Schedule 5 matter but a Schedule 1 matter?
Good afternoon, Dudu. Yes, and thanks for the invite. Look, they tried arguing that, look, we know there's an assumption that, there was a 2.5 million that was offered, but eventually the only amount that was paid was about 83,000, something that doesn't qualify that to be a Schedule 5 offence. To some extent, I think they were able to argue that, but the state also countered that. So it's all in the papers, and we'll just see how it goes.
And that's just it, because countering it, the state asked the question, well, what is corruption? Because a sum of 2.5 million rand was promised, and a payout was much less than that. However, the state arguing that, well, corruption has been sealed because you've already got a promise that was made, and you've got somebody who's accepted that promise as well.
Yes, no, true. I mean, if we are to argue quantum or the amount of money that was paid and promised, we are just trying to really classify this, corruption at a certain level. Is it a Schedule 5, which is very serious, or is it something lesser? But we're not necessarily arguing whether or not there was corruption. That has been established. It was there. It's just a question of the level, really, of this corruption that took place.
Nandipha Magudumana's team is arguing that she was kidnapped and she was taken to Tanzania against her will. The state challenging that, saying that she's also challenging her transportation back to South Africa from Tanzania, asking if indeed she was kidnapped, why then did she challenge that? One, also, why has she not opened a charge against the person she's accusing of kidnapping her, being Thabo Bester? She's not laid a criminal complaint.
Yes, and I mean, I think it was a very interesting argument from the defense or the applicant's attorneys that, look, there is no time limit within which you would be expected to file a criminal complaint against whatever that happened. We cannot say that because she did not do it within a certain time, then it has expired, or she was not going to do it. She might as well, could have chosen that I will report this or deal with it when the circumstances really allow and support me to do so. Maybe, she has a point. She wasn't in a position to do so previously. For a number of reasons, and she's only able to do that now when she's, she believes she's safe to do so.
Nandipha Magudumana in her affidavit argues that she's got parental responsibilities that she needs to execute. She's got siblings, she's got a family. Again, the state poking holes in that argument, asking that, or rather noting that the details of the kidnapping have not been ventilated. So she has not said how she was kidnapped, where she was kidnapped, which border gate was used as they left South Africa. Does the state have a case there?
To some extent they do, and I mean, remember this application is a case that, and my apologies, we just showed load shed. It's on Dr. Magudumana really to argue as the applicant, because she brought the application. We need to understand we're not in the main case yet where we need to argue now the details of everything, but to support her application, she would need to, talk to some of these things and also adduce evidence in support of her averments in that application. At least with her now, she doesn't have to prove this, beyond a reasonable doubt, because this is just a mere application where she will have to prove things on a balance of probabilities. Maybe that's the level that also would allow her to not go too much into detail. Hence the state, you would know that they indicated earlier that, look, we in a process like this, we stand and fall by the papers that we have prepared. We do not necessarily to go into evidence as if we are in a fully blown trial, criminal trial, where we would get an opportunity to cross-examine and.
The defense, Nandipha Magudumana's lawyer, is arguing that she can afford bail of 10,000 rand, as that was the amount of bail that her other co-accused received when they, or were granted when they then got bail, saying that any other amount would be unfair under the circumstances, and it would be tantamount to the refusal of bail.
Yes, I mean, at the end of the day, it's up to the magistrate to decide, because there's a number of considerations she would have to make in this regard, and Dr. Magudumana's position is different from the rest of the other accused. So when her situation is dealt with, we do not necessarily have to benchmark against what happened in respect of the other accused. So court is not bound necessarily by what it did in the previous accused bail application process. So it will have to look at her specific circumstances which are unique to her. As you would note, even when we talk assets, there's movable assets that are, well beyond R1 million. So the court will have to look into those things when it determines now the amount of bail to be paid, and also consider what happened previously. We also have a situation where there is a statement under oath that Dr. Magudumana had prepared for her High Court hearing, which we now know she lost it. And there's a lot of information in that affidavit that she deposed to that court may have to have a look at it in determining some of the issues in this process.
You speak of specific circumstances, or her specific circumstances. Will this then assist the magistrate in deciding whether to give her bail or not, and which way would it go? Because the state is arguing that she has provided an alternative address, meaning that she does not have a fixed address, and going as far as saying, how can the court trust someone who deceived the High Court and went to go claim bodies of people who are still alive?
Yeah, it really is not an easy one, Dudu. You look at what happened previously, and these are the considerations that are very important, especially for a judge that's sitting there, that, has this box been ticked? Am I confident that I have enough information, or I have enough evidence that will place me in a position to say the interest of justice permit, her release on bail? And you have to weigh, as a judge, these interests against her right to, personal freedom, and any prejudice that, she might suffer as a result of not being released on bail. And it's upon her that she she deals with these issues, she must argue that the interest of justice permit her release on bail. And essentially, there's a number of things she would have to, argue against strongly, that, she's not likely to endanger the safety of the public. She will not attempt to evade. And we know this one is a tricky one, given what happened in the past. That she will not intimidate or influence witnesses that are related to this case, or any evidence that's there. She will not conceal or destroy it. And we know what happened in the past. So it might be a very high hurdle to jump for her. So those are the considerations that the magistrate will have to really consider in arriving, at an appropriate decision.
Just very quickly for us, the state took exception a number of times mentioning Mr. Dlamini, part of Nandipha Magudumana's defense team, especially when it comes to the accusation of unlawful conduct in terms of changing the affidavit, and the state noting that just a word was changed, and only verbally, because the affidavit is still the same. The affidavit before the court is still the same. There's nothing that has been changed. Will that have any bearing at all on this case, their conduct, the legal representatives, that is?
Not really. It's not that material really. Especially, there are cosmetic changes that wouldn't necessarily affect, the nature and or structure of the entire matter. So in my opinion, I don't think it's it's that material, and it shouldn't necessarily have any bearing on this. Especially now that we are not, arguing the main case here. This is just, if you may, an intellectual issue that needs to be dealt with before we get to the actual trial.
Khumisi Kganare is a legal analyst. Thank you very much for your time this afternoon.